Okay, so let's get started. So hello everyone and welcome to this for IP Council webinar. My name is Marta Sierra. I'm Head of Marketing and Communications at 4IP Council, and I will be your host today. And today's webinar is called Sprouting Innovation, Cultivating Growth Through Community Plant Variety Rights. So I'm going to do a very brief introduction of what we do at 4IP Council, just in case you haven't heard, just in case you haven't heard about us. So we are a non-for-profit European research organization, and we focus our research on intellectual property rights and the impact on innovation. To develop this research, we work with academics, with other European organizations such as the CPVO, and with IP experts, and of course, always trying to make sure we choose the most relevant topics. You will be able to find on our website loads of free materials. Of course, all the research papers, the summaries. We have a case law area as well. And if you are a non-IP expert, we have a section called the SME's Corner that is particularly tailored for anyone that has to start from scratch, learning about the IP rights. And in this section, you will find the infographic that we have developed with the CPVO on plant variety rights. You will also see that we have a webinar section with all the recordings from previous webinars. And actually today's webinar that is also being recorded will be made available tomorrow together with the slides on our website. We also have an area called the IoT and cellular standards made simple, and it includes loads of videos and examples of the way IoT has affected our lives. And we have a podcast called IP Stories, where we interview founders and innovators, academics, basically telling us about their IP stories. And it's really interesting. So I encourage you all to go check it out. And we have started a new area called the AI Corner, where we have included a lot of material on artificial intelligence and also all the raising questions regarding intellectual property because of AI. Okay, great. So without further delay, it is my pleasure to introduce our speaker today. He is Andrea Pontecorvi. Andrea is a legal advisor in the legal department of the Community Plant Variety Office, the CPVO, in Angers, France. Before joining the CPVO, he worked with international law firms and global companies where he gained expertise in intellectual property law and commercial litigation while developing a strategic approach to managing IP assets. He studied law in the United States and Italy and has been admitted to the practice of law in both jurisdictions. So before I hand the floor to Andrea, I would like to just give a final remark to our audience. You will find our Q&A tool at the bottom of your screen. You can use it at any point throughout the presentation. We will take the questions on the Q&A after Andrea's presentation, but you don't have to wait until then. You can start sending your questions straight away. Thank you, and Andrea, the floor is all yours.
Thank you, Marta. Hello, everybody. As Marta kindly said, I am a legal advisor at the CPVO. I work with CPVRs, a lot of acronyms, probably things that nobody heard before today. If you did good, we're in big progress. But you probably heard of CPVR from the infographic that was published on the 4IP website, which talked about 4 reasons to have a CPVR. The purpose of today is to give a little bit of an overview of what a CPVR is so that we can connect the dots between why should you get a PVR, understanding what a PVR is. So let's start our presentation of the CPVRS. This is another acronym which stands for Community Plant Variety Rights System. And the purpose is to understand each of these letters to get this understanding of the system. So the first letter is community. But as a general overview, before understanding the community, we have to understand what the CPVR is. As I said, probably some of you have heard of the CPVR for the first time today or read the infographic. This system, however, dates back to the early years of last century and comes from an international agreement that gave rise to the UPOV Convention. Within this UPOV Convention, after the consequences of the UPOV Convention, the European Union adopted the basic regulation, which is the regulation number 2100 of 1994, which regulates this new intellectual property right and established the CPVO. I don't want to go too much into the details of the legal framework because it's kind of boring, and you can, if you're interested, we can talk more about it later, but for the purpose of this meeting, let's delve into these 5 letters. So the first letter is C as community. The community plant variety right comes from the European Union, which is the community. The community part is the part that is dealt with by the office, which is the Community Plant Variety Office, which Marta kindly said as this seat in Angers. We are 50 plus employees. We work in every language of the European Union, and we are responsible and competent for the granting and management of the community plant variety rights. Our mission is to deliver and promote efficient intellectual property system to support not only the interest of the private, but also of society as a whole. Kind of a little trivia, we have been working for more than 30 years. We have celebrated our 30th birthday last year, and we are in our 31st birthday now. So it's also the office is a little bit older than I am, but a bit older than I am, yes, but it's fine. Okay, now let's see the P and V. Plant variety. What is a plant variety? Okay, from a botanical point of view, the taxon of plant variety, the definition of plant variety is given by Article 5 of the basic regulation. This is a legal construct because the scientific definition of variety is not so clear. We know that the species is the lowest rank of the botanical taxonomy. The variety is defined as a plant grouping within a single botanical taxon that is defined by its phenotype. To understand this, we can give an example. It's like when we are talking about plants, it's like we are discussing about where someone lives. We have first the country, then the city, then the neighborhood, then the street, then the building. The variety is basically the building where someone is living. So it is the lowest possible definition of a plant, which has to have, in order to be a variety, has to be able to propagate in uniform manner and has to be distinguishable from other varieties and from at least one characteristic. The definition, the scientific definition, legal definition of variety is broader than the ones that we can actually protect as plant variety rights. Because between this group of plant varieties, the one that can be protected are the one that meets this requirement. These are the substantive requirements that a variety has to have. And these DUS requirements, which, as we said, is distinctness, uniformity, and stability. The novelty, meaning that the variety has to be new, meaning that it does not have to be commercially exploited before the application date and outside of this of a grace period. The grace period is usually 1 year before the application date in which commercial exploitation is allowed. And it has to have a name, a variety denomination. The name comes with the variety and is used to identify the variety also after the community plant variety right has expired. Moving forward, we have the letter R. So once we understood what is a plant variety, now we'll discuss what is a plant variety right. The plant variety right is an intellectual property right that covers plant variety, granting an exclusive right to the owner to exploit commercially the variety. It means that the owner is the only one that can have a sale authorization, that can therefore export, import the variety, that can reproduce the variety, and can dispose of the variety as it wants. This is a sort of monopoly that is granted by the system to reimburse the breeder from the innovation and the investment that he had made to develop this variety, and as such has to be limited in time. we said the duration of the plant variety right is generally 25 to 30 years, depending on the species. This difference between 25 years or 30 years depends on the species, because some species require more time to grow and to be commercially exploitable. If we think about a tree, the seeds, the fruit of the tree, sometimes the trees produce fruits when they are a little bit older, whereas raspberry, for example, they produce fruits every single year. Therefore, from this characteristic, we have the difference in duration for the right. What does the right protect? The right protects the variety constituents, meaning all the part of the plants that can be used to reproduce the plants. This is different from the harvested material, which in general is not protected as such, meaning that the right protects the variety constituents, not the harvest material, but it can protect the harvest material when it is not possible to protect the variety constituents. This is called the cascade principle. We can think of the example of a variety that is grown outside of the territory of the Union, so where there is no protection, and is imported afterwards. In this case, we need to protect the fruits of the variety because we were not able to prohibit the propagation of the plants. Who can have a plant variety right? The basic regulation is clear that the right has to be given to the people that are entitled. Entitlement is given to the person or people that bred the variety, meaning that bred, discovered or developed the variety. There has to be a contribution to the development and the discovery, the breeding of this plant. The entitlement can be freely transferred between people, so therefore it means that if someone develops a new variety, it can dispose of its right and it can be applied for by another person, but and can also be granted to natural person or legal people, meaning that both physical and individual, and also companies can be considered the holder. Now we go to the last letter, which is S as system, which is the purpose of the community plant variety system and the community plant variety office. By building this system with the regulation of 1994, the purpose was to have one single community plant variety right throughout the entire territory of the European Union. There are national plant variety rights. However, the advantage of the community plant variety right is that with one single title, with one single application, one single procedure, one single technical examination, we have one right that can be managed as if this was one, but it's valid throughout the entire 27 states of the European Union. Therefore, it can be enforced in every single country. This means that for the people, for the holder of the right, it means less time, less money, less cost, less costing management of the right with a broader protection, because the protection is extended for all the territory of the European Union. This is the community plant variety system. Now we are going back to look at the infographic. The infographic that we said was giving 4 purposes to why have a PVR. Given what a PVR is, this has both an impact and a value for individuals and for the public itself. And now we're going to see what is the advantage, what is the benefit that it grants to privates, and the benefit that it grants also to the public. From a private point of view, the PVR, then the community plant variety right as well, is an asset, is an intangible asset that has an economic value. It can be disposed of, licensed, it can be sold, it can be bought. So as it is an asset, an intangible asset in the portfolio of a company or of a physical person. But why would someone want a PVR? Because it grants you market access, it grants you, it unlocks you collaboration opportunities, it has a strategic value, and it also opens the door to funding. What do we mean? Market access. The plant variety right grants you an exclusive right to exploit and commercially utilize a plant variety. It opens you a new market. Plus, it grants you a protection for something which is the plant variety, which is something that exists. It grants a protection to the plant variety that is unique, is tailor-made. It's specifically tailored, specifically developed to protect the specific needs of plant varieties, which are very unique given that plants are an organic thing that as such does not really follow the rules of the law, but develops in its own way. So the purpose of the community plant variety right is to follow these needs, is to follow these peculiar aspects of the community plant of a plant variety, and to address, to give a response that fits the market needs and the legal framework. It also unlocks collaboration opportunity, because once you have a plant variety right, as we saw, there are many actors that play in the plant variety right system, which are the breeders, the developers, the marketers, the sellers, the resellers. All these actors can collaborate, not only for the commercial exploitation of the variety, but also for the development, for the discovery, for the breeding of the variety, which means that there are possibility to partner with public and private institutions in different fields, which is not only we have to sell the plant variety. Because the plant variety at the end of the day has its own value. And if you are granted, if a company is granted PVR, it means that this company has, this plant variety has met all the requirements for the grant of a community plant variety system, from the community plant variety right, which means that the variety is stable, is uniform, is distinct, which gives to the market the impression that it is reliable, which consequently makes the company look more reliable and more secure when it comes to funding. For the strategic value, plant variety rights system is a closed system. There are not many actors that operate, and then there are the title holders of a community plant variety right, which means that the holders of a community plant variety right can actively engage in discussions for the development of the legal framework, and they can shape the best practices of the industry. Because what this means is that by applying for a plant variety that is very valuable for the market, but that grants an exclusive right to exploit and to commercially use that variety, it pushes all the other competitors to meet the same standard. Therefore, the title holder of a variety can shape the actual market by having this plant variety right. As for the public impact that the community plant variety right system has, just a brief overview. Being an intellectual property right, it encourages innovation, because as we said, by having a plant variety right, you have the exclusive right to use the variety. The purpose of this right is to reimburse the breeder of the costs in discovering, in developing, in breeding the variety, so that they can have a profit and also recover the costs. And by creating this system, the system is encouraging innovation, is pushing people to discover more, to develop more, and have more varieties that address more needs, that are more productive, more efficient, and that can meet the needs of the market. One of these needs is sustainable food production, because with this plant variety usually are more efficient, they are more reliant, they are more resistant to the climate changes. Therefore, there is more food security, more food quality, and more food sustainability. Likewise, there is more production of plant varieties and more production of agriculture crops, which creates a higher employment rate, an increase in GDP, and as an indirect effect, also it's beneficial for the environment, because it lowers the emission of greenhouse gases. By creating plants that are more efficient, there is less need of transporting the varieties. We think of the example of having an avocado, which can grow, I don't know, also in England. By having that type of avocado, we don't have to ship avocados anymore from Peru. Therefore, it diminishes the amount of GHG necessary to introduce the avocado on the market, as well as the variety is more efficient. It fosters the use of an alimentation that is based on plants, therefore having this positive impact on the environment. This was to connect all the dots from what is a plant variety right to why would someone be interested in a plant variety right. As a takeaway, I went around the office where we have a technical unit, a legal unit, and a register unit, which deals with the contact with the public, and asked them for some useful insights and tips that they would give to the people, to the prospective or an actual title holder. And this is a small brief list that I would like to give you to have a takeaway, a practical takeaway from this presentation. The first one is to file early, but only when you're ready, which means that do not wait. If you want to apply for a community plan variety right, do not wait for the day before the deadline, because sometimes there are things that are missing, things that are not working, things that go wrong. And by filing at the very last moment, the risk is that you miss the deadline and then you have to wait for a whole new year, with consequences of the novelty issue, because the plant, if you apply the following year, then there is no new anymore. And also the risk that someone else applies before you. Therefore, yes, be fast when you apply, but only when you're ready, because if you apply when you're not ready, then you still have to produce the plant material. And if we have to wait for the plant material to be ready, then again, the application must shift, it's rejected, and the new one has to be filed. That's the first advice. The second one is to keep clear documentation. By keep clear documentation, we mean that we observed that many of the challenges that our client, the title holders encounter, is that it comes when they have to prove their allegation. The allegation can be made during the application stage, when they're asked to prove that the variety is novel, to ask to show what type of disposal of the variety has been done. There is some objection to the application, and therefore they have to prove that the variety was actually developed by them. By keep clear documentation, we need to have some physical documentary support to give evidence of what they're saying. This should start before the application process, because this document has to be ready. The third advice is to, sorry, the catchy phrase, I apologize for that, water your plant variety rights, which means that once you got a plant variety right, once you are granted the right, the variety should not be just simply forgotten. It is as if it was a plant. It has to be watered. You have to be due diligent in maintaining your plant variety right. There are some deadlines that has to be met for the payment, for communication with the office. And within this advice, we would like to point out that there is a platform that the office uses with all the title holders, which is called CPVR. And the biggest advice is to get familiar with this platform, because this platform is the place where communication takes place between the office and you. And we send the communication through the platform, but also you should send communication to us through the platform. If the platform is not familiar, if you're not a title holder already, then just simply contact the office wherever the problem is. This is the final advice, probably the most important, which is contact the office, ask the office if there are any doubts as to what is the procedure to obtain the plant variety right, what are the documents, the plant variety material, the deadlines. It's better to ask a question to the office than to create a problem that then needs to be fixed. Finally, and here I attach to what Marta was saying before, there is a tip for the SMEs, which is to probably try to explore the possibility for the SME fund, which is a particular fund sponsored by the UIPO, which is the European Office for Intellectual Property Rights that deals mostly with trademarks and designs. But this fund is given to all SMEs that want to foster the intellectual property portfolio, which also includes plant variety rights. And it works by granting some vouchers that can be used to recover some of the costs that the SME face to obtain an intellectual property right, including the plant variety rights. There are the links for, there is the link in the following slide for the SME fund. This also can also be found here. These are some other useful links. I hope this presentation has been a little bit clear, and then now there is a better understanding of what the community plant variety right is, how it works, and what are the benefits. And I think that we can open the Q&A session.
Yes,
Thank
sorry,
you.
it was taking me a while to connect the Thank you so much, Andrea. I think the presentation was very clear, and I really like that you started with the letters of the CPVRs, because it's true that it's a very good place to start, and we are going to be repeating that name many times. So We have shared the link to the infographic, and I think my colleague Sofia is also going to share the link to the semi-fund. But thank you so much for also adding the links on the presentation. So we have received some questions. So I'm just gonna go ahead and start the Q&A now. And again, I invite our attendees to keep asking questions because I see that this is a very interesting topic for all of them. So the first question that I would like to ask you, Andrea, is if my company is based outside the EU, but we want to commercialize varieties in Europe, can we still apply for a CPVR? And are there any additional requirements for non-EU applicants?
Okay. The short answer is yes, you can still apply. What does it mean? That the community plant variety right system, it is valid in the European territory, but it's open to everybody. As someone from Europe can apply from a national community plant variety right, from a national plant variety right in a third country, people from third countries can apply for community plant variety rights in the European Union, which means that they will have a title that is enforceable throughout the European Union. There is an additional requirement when this happens, which is for the office to have someone, a point of contact, someone to interact with, the individual, okay, if it's the physical, a natural person or a legal company or legal person outside of EU, should name and appoint a procedural representative within the European Union so that the office has its point of contact for communicating and, again, for using that PVR platform to send the communication and everything. But yes, it's totally possible.
Okay, great. That's good news. Okay, next question. If we already hold national plant variety rights in some EU member states, what are the advantages of also applying for a CPVR? And how do these rights interact?
Yes, I can see the confusion there because there are these two systems. So there is the community plant variety right system and the national plant variety right system. These two systems can coexist. They do coexist and they move in parallel, basically. There are some point of contacts, especially during the application stage, but that's not the core of why they coexist. The easiest example that we can think about is someone that has a national plant variety right and then later applies for a community plant variety right. What does happen in this case? The thing that happens is that they still coexist. They are still both valid, but once a community plant variety right is granted, the national one becomes ineffective because protection can only be one. Therefore, the national one is still alive, it's still there, it's still valid, but it becomes dormant, it becomes ineffective. Meaning that if for whatever reason the community plant variety right will be cancelled, it dies, it expires, whatever happens to the community plant variety right, it does not impact the national plant variety right that keeps going with its own life. So it's going towards its own expiration date and will revive if the community plant variety right expires before the national one. So yes, okay. They can coexist. It's not an impediment.
Okay, perfect.
Oh, sorry. What are the advantages? Yes, no, because there was the second part of the question, which is that the advantage is that by having multiple national plant variety rights, again, there is a multitude of platforms, a multitude of deadlines, a multitude of application processes, whereas the community plant variety right is only one, which is valid throughout the entire European Union, and is treated by the enforcement as if it was a national one. So the validity national-wise is the same. It's only easier and it's a broader scope of protection.
Okay, but in terms of the number of years and all those things, like it's more or less the same?
It's more or less the same because this type of requirements, they follow the UPOV guidelines. UPOV is this international agreement that it's above all of this. It's a convention which gave a suggested legal framework. So everything that comes afterwards usually is in line with the UPOV convention. There may be some discrepancies within national and community plant variety rights as also to the scope of protection, to the duration, but usually they're all like pretty much the same. If there is some specific need, I would advise to request legal advice to assess what is better for the specific circumstance for the specific company. because there are some differences, usually are not that many.
Okay, perfect. Okay, the next question says, does the official variety denomination needs to match the trademark or commercial name we use, or is it okay for them to be different?
Okay, well, the variety denomination. To address this question, we should probably first distinguish the purpose of the variety denomination and the trade name, because the trade name is what is called commonly known as a trademark. For example, Coca-Cola, let's say, and the variety denomination serves two very different purposes, because the trade name, the purpose of the trade name is to identify the origin of the product. So who is the person behind that product, because it wants to be remunerated because it's producing the product, because the product is more reliable if it comes from a specific source. There is all like commercial needs. The variety denomination serves also another public interest, which is different from the trade name, which is to identify the variety, because the variety is something new that has to have a name to be talked about. So it has to come with a name, otherwise we don't know what we're talking about. Therefore, we give that a denomination, which is the variety denomination. Now, when it comes to the interaction of these two, they can coexist as well. Probably the most common example and easier example to follow is the Pink Lady example. Pink Lady is a type of apple, but it's the trade name, because the variety denomination is actually Eclipse Pink, which is the type of variety. The trade name is more common because it's the one that is used in the market, it's the one that people know. And another example could be probably for people that are not really familiar with the plant variety system. If we think about pharmaceutical drugs, pharmaceutical products, is the generic name, basically, the variety denomination. We're talking about paracetamol, is paracetamol. Then it can be tachipirina, it can be whatever else is sold national-wise. They do interact, that is, which means that the variety denomination can be similar to a trademark, but it's strongly disadvised because it can empty the trademark. For trademarks, they cannot be as the same as the variety denomination. So if there is a variety denomination, it is an impediment to the granting of a trademark, because it is something common. It's like calling water water. You cannot manipulate, you can have a monopoly on that word, because it serves a different purpose.
Yeah, of course. Yeah, it would be very confusing for
It would be very confusing.
everyone. Yeah. Okay, that makes sense. Okay, the next question says, for someone applying for the first time, what are the main stages of the CPVR application process, and how long does it typically take?
Okay, so once the variety is ready, because it has to be ready before application, the application can be filed. How does it work? The office proceeds with three different types of examinations. There is a substantive examination, a formal examination, and a technical examination. This is the structure. The formal examination is the paper examination, meaning that it's just like a paper check that all the documents are completed, that everything is properly filed. Then we have a substantive examination assessment, let's call it assessment, which is directed at us assessing whether the variety is novel, if the person that applied is entitled, and if the variety denomination is suitable, because there are also, as for trademarks, there are some rules. For variety denomination, there are some rules. Not all the words can become a variety denomination. Little advice here, I take the opportunity. When you're giving a name to a variety, be creative. Because one of the biggest issues and biggest problem that we encounter with the variety denomination committee is that sometimes words are too descriptive of the variety, and that's an impediment, unfortunately. So if you want to call your red rose already, or scarlet, it's a little too suggestive of what the variety is, and we go back to it not being sufficiently useful to identify the variety. So this is a small advice that we give when it comes to variety description, the variety denomination. Then we have in parallel the technical examination, which is the one that is conducted by the examination offices. The examination offices are these offices that have a specific relationship with the office. They've been entrusted, meaning that there are some standard of quality, and they do work with us to conduct the actual technical examination. There are various examination offices. They can be entrusted for specific varieties depending on the climate, depending on the condition. But the purpose is that when there is a candidate variety, it is grown with the same condition of the reference variety to observe directly, physically, side-by-side comparison if there are distinctions, there are some characteristics that are unique to that variety that the reference variety does not have. So the examination is directed at assessing the US requirements. Okay. As to the duration, that depends. It depends on the specific variety, on the specific species that the variety belongs to. Because when some varieties, as we said before, the life cycle starts and ends in 1 year. Therefore, it can be observed in 1 year. They get some technical guidelines. We have to follow some technical guidelines that are issued by the UPOV because they are uniform throughout all the member states, so that these varieties are assessed on an objective level, as much objective as possible. But so there are some varieties that can be observed in just 1 year, some varieties that they need more years, because, for example, if one applies for an apple tree, before it starts giving apples, the apple tree must be a little bit older. So it takes more time to observe the apple from the tree. So this technical examination differs, and as a consequence, the time for application, they differ depending on the species. They can go from 1 year, 2 years, usually, to more than 3 years.
Of course, yeah, it makes sense that it depends on, I mean, we are talking about organic things, as you said before, like it's
scientific definition, yes, organic things. I know.
Yes. Yeah, but yeah, it's true that it's more tricky.
Because
okay, so
sorry. Just because some misconception, usually someone thinks about innovation, invention, they think about patents, but they work completely different. So if someone is familiar with patents, that was one other advice I received from the technical unit, from the colleagues, forget everything. They do not work the same, because patents, they respond to a specific need, that is the technological innovation. When it comes to plant varieties, given that it's an organic thing, a living thing that has its own mind, basically, because it develops, it grows as it wants. All sorts of things can happen when a plant is growing. The system has to be ready to face all those things. So it means that it's different. There are specific requirements, there are different requirements specific to address this characteristic of the plant system.
Yes, exactly. And nature will take its time. You cannot rush it. So, okay, great. The next question, I think it's very interesting. So regarding novelty, which type of sales or disclosures would actually jeopardize it? And are there any exceptions, for example, for trials or testing?
Okay, yes, it's a very interesting question. Novelty, we said that what is novelty? Recap, novelty was that requirement that plant has to be new, because if you want to be the owner of a variety, you have to be the developer, so it has to be something new. This is shared with the patent system. The novelty requirement means that the variety should not have been commercially exploited before the application. There is a grace period. The grace period, also in this case, depends on the variety. You respond against to that need that some varieties are easier to grow. They produce fruits very fast. They can be harvested very fast, so they're profitable in a short amount of time. Some others need more time. And also depending on if the commercial exploitation was done within the European Union or outside the European Union. So there is a specific time frame enshrined in the basic regulation that can be monitored, can be reviewed. Not every single disposal of the variety destroys novelty, because it's easier to say what does not destroy novelty than what destroys novelty, because what destroys novelty is a broad concept, which is commercial exploitation, which is not really defined. What does not destroy novelty? So what it is allowed to do with the variety without risking it not to be new anymore. It can be used for trials. It can be displayed in official exhibitions. It can be used for testing, for meeting statutory requirements. For example, sometimes there are some statutory requirements for phytosanitary purposes. So you have to to send the plants to the authority, to the national authority. That disposal, because it was actually like it was disclosed, the value, it was sent to someone else, so to a third party, does not destroy novelty. The one that is probably the more intuitive is any disposal that was done without the consent of the owner, which means if the value was stolen, basically, that's not a fault of the title owner, therefore it cannot destroy novelty. So there is this number, but it's not an exhaustive list, it's not a specific list, it depends, there is some case law on this to define what is commercial exploitation and what is not. But some uses are allowed without risking again to lose novelty.
Yeah, that makes sense. Okay, and the next question says, once a CPVR is granted, are there situations where someone can use the protected variety without the holder's authorization? For example, for research, breeding, or other specific purposes?
Okay. In this case, we are not talking about without the owner's authorization, meaning that it's stolen, but when after the variety has been granted, can third party use it without paying royalties? That's framing.
Yes, without authorization sounds a little bit like.
Of course, like one of the easiest examples is if there is a protected variety, private use it is allowed. If someone wants to grow a rose in his garden, nobody can enforce and can claim that the variety is protected. So that's the type of use that we're referring to. Yes, that type of use is allowed. There is also some exceptions, because again, the plant variety system does not only look at the interest of the breeder or the interest of the title holder, but also of the community as a whole, of the public interest. Therefore, one of the biggest exemption is the breeder exemption, which means that plant variety can be used, protected plant varieties can be used without the authorization, meaning without paying licenses, without paying royalties, to breed new varieties. This is the biggest probable difference with the patent system, which means, because in this case, if I develop a new variety which comes from a protected variety but is sufficiently distinct from the parent variety, I can protect the new one, the daughter, without having to protect, without the consent of the owner of the title on the parent. So that fosters innovation, because people can use that and produce and develop, discover, breed new varieties, so that the system can still grow, can still innovate, and can address these needs that are ever changing in the market. Another one, in this case also is pretty intuitive, is the research exemption, because it's for research purposes, universities, institutions, they can research, they can use that variety, they can grow them and observe them as how they respond to specific climate changes, how they respond to a specific environment, how they respond to specific pests, to specific products. That can be done. That's a trial that is research purposes. As long as it's not a commercial implication, is allowed. Another exemption can be the agriculture exemption, which allows farmers to use the harvest material to propagate a new cycle of products, but this is a little more niche, so I will not go there because it can create confusion. But let's say that the biggest ones are breeder exemption, research exemption, and private use. Those are always allowed. Plus, this can also be of interest, the concept of exhaustion. The concept of exhaustion is shared also with trademarks, which means that once the title holder disposed of the variety, it can be freely disposed by anyone else. So if I sell the rose, then the gross reseller can resell it to the specific store, to the little store. That is the concept. With the exception, given the specific need, that it cannot be used to propagate new material, because otherwise it would defeat the purpose of the right.
Okay, that's very interesting. Okay, so the next question says, if a company restructures or it's acquired, it is possible to transfer a CPVR to another entity. And what does that process involve?
Okay, yes, as we said, the community plan variety is an asset. It's an intangible asset, but it's an asset as any other asset. So it can be freely disposed. It can be the object of sale. It can be the object of a transfer, of a merger and acquisition operation. And also, like, if the company is restructuring, it can change the name, but the variety survives this change of the name. It can be freely given. So yes, it is a good as any other good when it comes to company relationship. In case that happens, if there is this transfer between two companies or two people, two persons of this of a community plan variety right, the requirements is they can have their product, their contract, which deals with the civil effects of the transfer. They have to notify the office, because we keep a database that has to be updated with who is the title holder, and in the case that the title holder changes, it has to be notified so that we can update the database. Also, in this case, there are specific forms that have to be filled, but contact the office and you will receive all the necessary paperwork. It's nothing complicated to notify us of this change so that we can notify the public of the change.
But yeah, I think that's something that happens more or less the same way with any other type of IP right.
Exactly. Yeah. Yes.
Okay, so the next question says, you refer to the US testing. Could you briefly explain what distinctiveness, uniformity, and stability mean in practical terms for applicants?
Yes, I don't know if we can get back the presentation, because I added one slide, but I didn't know if we had time to go over that. But since we do, let's if we can.
Yeah, I think so. Sophia, maybe you could share the presentation. Hopefully she's listening.
Yes. Okay. And it should be the last one. Here it is. This is I really like this slide, because it gets like the core idea of what distinctness, uniformity, and stability is. When we talk about distinctness, it means that the variety has to be different from something else. Otherwise, it is not new. It is not something that has been developed. It's the replica of something that already exists. Therefore, there has to be at least one characteristic that is different from the closest reference variety. What does it mean? In practical terms, that when the testing is being done, the examination offices assess and what are the varieties that are similar to the candidate one. They're put side by side, they're grown side by side, and the different characteristics are observed. If they are sufficiently different, then the variety is distinct, and as such could be protected. The other one is uniformity. Uniformity means that the sample presents the same characteristics. If we think about flowers, it's easier probably to think. If we have a bush of roses, they all have to be the same color. If the characteristic is the color, meaning that the particularity of that variety is that it's black roses, but the plant has to produce all black roses. It cannot produce 6 black roses and 1 red, because it would not be uniform. Stability, it's strictly linked to the uniformity and distinctness, but it means that with each life cycle of the plant, so when it propagates, the daughters of the plant has to present the same characteristics. Meaning, from the one that is the bush that produces black roses, if I cut a stem and I plant the stem, it has to be another bush that produces black roses. So these are the 3 characteristics, and this is why technical examinations take time, because this has to be assessed, so they have to be observed. There have to be a new generation of the plant to observe stability. That's why there is the long years when we talk about technical examinations.
Okay, that's really interesting. Yes, I was only thinking about distinctiveness, but of course, like the other two are as important. Okay, great. So I'm gonna go ahead to the next question we have received. Yes, we have time for another one. Once a CPVR is granted, who is responsible for enforcement? Does the CPVO play a role, or is it entirely up to the right holder to take action? This one I think is very interesting as well.
Yes, because this is what happens afterwards. Because we're talking about, okay, now I have the right, what happens afterwards? Yes, you have the
Exactly.
right. Unfortunately, it's not us. The CPVO is an administrative body that manages the application process and the life of the right. Enforcement is not within our jurisdiction. It is left to the national courts and to the national authorities. For example, the customs or national courts. They are the ones that will enforce the right, and which means that no, you're not left on your own. You do not have to private justice your neighbor because he's stealing your plants. Those rights can be enforced in a court of law within the jurisdiction of the European Union. So in each national court, they do recognize the existence and the validity of a community plan variety right, and they will be enforced. Again, also when it comes to this type of proceedings, documentary evidence could become important. So keep clear record of what is done, who you send the variety to, what were the contractual framework, so that if it comes to that, you're shielded. You have a better chances to have it easily solved.
Yes, of course. Yeah, I think that's very good advice. Um, okay, and when it comes, when an application is filled, what information becomes public? Does the variety itself enter the public domain at any point?
Okay, I think I see the concern here. No, okay. The variety, yes, becomes public domain, meaning that some informations do become public.
Okay.
Also, we are a EU agency. We have to disclose if there is a public access request. The document has to be handed over. But what becomes public? It becomes public the name of the title holder, which is the public database. What is the variety? The result of the technical examination. The concern here, I think, relates to the trade secrets. If there are some information that we don't want to share because we're afraid someone will steal or copy our variety. In that case, the response is it depends. But I don't want to be the lawyer saying it depends just to cover up. No, depends because there is a specific provision in the basic regulation that states that when it comes to hybrid, specific informations are kept confidential if the applicant so requests, and are those information that are necessary to replicate the hybrid. So meaning that this way you're not given the recipe to produce your variety as it was. When it comes to other informations, it depends. There is a case-by-case analysis by the office. It depends on the interest of the parties, so it gets a little bit more nuanced. But unlike the patent system, where everything becomes public domain because that's the purpose of the patent, but as a consequence, the title holder protects everything that comes after the patent. In this case, there is a higher level of confidentiality, and that is kept in order not to allow this propagation and the possibility to copy the variety.
Okay. Okay, so yeah, I think that will make them more calm about it. I think we don't have time for more questions, so we will have to leave it here. But it's been so insightful, Andrea, and so interesting to learn about this type of IP right. I think we don't hear enough about it, so thank you so much. And Sofia, maybe you can share the last slide with our audience. Um, we will be, as I mentioned before, we will be sharing the recording of today's webinar together with the slides. Everything will be made available tomorrow on our website. You can follow us on X, LinkedIn, YouTube, Instagram, always with a handle at For IP Council. And you can also subscribe to our newsletter. This is the best way to find out about our upcoming webinars and any new free material that we create to help you all to understand better all types of intellectual property rights. And you will also receive a very short survey tomorrow to ask you if you liked the webinar, and also if you have any other topics that you would like us to cover in the future. So it would be great if you could give us this information. It would be very helpful. Well, thank you and bye-bye.
Thank you, everybody. Bye.